Good morning, everybody. I'm Andrew Redburn from Active Law. I look after the dispute resolution for the body corporate division within the firm. And this morning I'm going to talk to you about the enforcement of bylaw regime. Now, I want to make the point, as a preliminary point, that I'm not here to defend the process. I'm here to explain the process. In many respects, the contravention regime is unreasonable and unfair for a body corporate. Taking the example of short-term letting, where often the culprit has moved on far quicker than you're able to A, issue a contravention notice, and B, sometimes even find out the name of the culprit. And as Mark has explained in his presentation in relation to car parking contraventions. Now, we certainly don't think it's fair. We share the same frustrations as you do as professionals, and the only way we're going to affect any change is to start lobbying our local members, as Mark mentioned previously. I tend to put a fair bit of detail into my slides. The main reason being that it at least gives you a bit of a reference document for when you get home and you realise you've actually remembered about 10% of what I've said this morning. To move through the topics that I'm going to discuss this morning, first of all, I'll give you a bit of a background to the presentation. We'll talk about a general overview of the process. We'll look at the types of contravention notices that can be issued. We'll look at some steps you need to take before you issue a contravention notice. We'll talk about the correct process to go through when issuing the contravention notice. We'll look at some case studies of where people have gone wrong in the past. We'll look at what you need to do to enforce the contravention notice. We'll talk briefly about urgent bylaw enforcement, and then we'll hopefully give you a bit of a take-home summary of things you need to think about. So in terms of background, I'm talking about schemes consisting of more than 2 lots this morning. Different forms and different provisions apply for 2-lot schemes, and I won't be talking about that. I'm talking about bylaw contravention notices, not code contravention notices, which apply when somebody, as in a caretaker, body corporate manager or committee member, contravenes the code of conduct under the Act. And I'm not talking about remedial action notices relating to caretaker disputes. I'm looking at it from the perspective of the body corporate enforcing the bylaws, issuing the notice, not an owner. As people may realise, an owner has got a right to enforce bylaws if they issue a request to the committee first to issue a bylaw contravention notice, and if the committee doesn't do that within 14 days. Then the owner themselves have got a right to take enforcement action. But other than that statement, I'm not talking about that this morning. I'll make the point the bylaw needs to be valid and enforceable, and as Mark touched on in his presentation, it shouldn't impose a penalty, and it should not be prohibitive in nature, only regulatory. In quite a remarkable leap of circular logic, under section 94, subsection 1, a body corporate must enforce its bylaws. So that's a compulsory term, must enforce. However, that is subject to an overriding requirement that the body corporate has to act reasonably in doing so. So that unfortunately leaves us with a situation where there can be a very grey area as to whether the body corporate is actually acting reasonably to enforce a breach of its bylaw, and that's just an unfortunate consequence of that overriding requirement. The 2 types of notices that can be issued are the Form 10 Notice of Continuing Contravention and a Form 11 Notice of Future Contravention. And again, I'll talk on these in a bit more detail shortly. Just to give you a general overview of the bylaw enforcement process. So assume there's a breach of a bylaw by an occupier. The committee has got the authority to issue a contravention notice in relation to that breach. They then have to look at enforcement of a contravention notice, assuming that the occupier hasn't addressed their behaviour or their conduct. And there's 2 ways that can be done. That can be done through the BCCM adjudication process, and the committee has got the authority to commence an adjudication application, or you can take it directly to the magistrates court in some circumstances, meaning that there has to be sufficient detail of the breach in the contravention notice, and if there is, then that creates an offence if the occupier doesn't abide the notice. Assume you've gone through the adjudication process. The order is then issued by the adjudicator, and that would be to the effect of that the culprit must comply with the bylaw. And if the culprit then does not comply with that adjudication order, that then needs to be enforced in the magistrate's court. If you proceeded straight to the magistrate's court, then if the culprit did not abide the order of the court, the court would issue a fine in relation to the failure to comply with the contravention notice. If you have to enforce the adjudication process through the magistrate's court, then the court would then impose a fine for the failure to comply with the adjudicator's order. So you may now be sitting there thinking, why would we go through the adjudication process given that we end up at the magistrate's court in any event? And that's a question which I'll answer further on in the presentation. So what are the two types of contravention notices? We mentioned the Form 10 Notice of Continuing Contravention and the Form 11 Notice of Future Contravention. How do you know which one to issue and when? So the continuing contravention applies if there's a breach of a bylaw and it's likely the breach will continue. The future contravention notice applies if there's a breach of a bylaw and it's likely it will be repeated. So that's the difference. Is it a continuing contravention or a future contravention because it's going to be repeated? The difference is there an end to the breach and possibly a new breach? And that can be daily or even more frequently. And if it is, then it's a future contravention. If there's no end to the breach, it's a continuing contravention. And it's going to be easier to explain through a couple of examples. Take, for example, a bylaw not to alter the appearance of a lot without approval of the body corporate. Once that's breached, and until the alteration is removed, the contravention remains. Whereas if you look at a nuisance bylaw or the hanging of a towel on a balustrade or balcony bylaw or parking on common property, even though the offence the breach may remain for a few days or may be repeated continually throughout the day, there's an end to the breach and a new breach commenced. And so that's probably the easiest way to try and remember the difference between the notices, but it can be difficult. So in summary, if it's a continuing breach, use a Form 10. If it's a repeated breach, use a Form 11. Now, it's not always so easy, as you would expect. Let's look at the example of Ulysses Blue Estate. This was an adjudication decision relating to the carrying on of a childcare business from a residential lot within a scheme in contravention of a bylaw which prohibited regulated that behaviour. The committee issued a notice of continuing contravention. So the question is it a continuing breach or is it a repeated breach? Does the breach end at the end of each day when all the kids leave the premises and recommence the next day? Does anyone have a stab at whether that's right or wrong? No? Continuing? Yeah, I agree. I think that when you hold yourself out to the general public at large that you're conducting a business from the premises, until you cease holding yourself out, my view is it's more likely to be a continuing breach. But that's one of those situations where it can be difficult to decide between the two, and I think that in that sort of situation you could probably use either form, but I would prefer the continuing contravention notice. In Huntingdale Lodge, that was an instance, it's a rather unremarkable case relating to simply breaches of nuisance bylaws, car parking bylaws and depositing of rubbish bylaws. But in that case, it's quite clear they are repeated breaches. So a future contravention notice should have been issued, but instead the committee issued a continuing contravention notice. And the adjudicator in that case just simply considered it an irregularity and didn't think it invalidated the process. So to give you a little bit of comfort, I haven't seen any adjudication where the point has been taken that the wrong form was used and that has led to an invalidation of the contravention notice. But as a matter of best practice and to reduce any unnecessary argument, if the notice is challenged, make sure you use the right form. So what can you do before you issue the contravention notice? How can you head these things off at the pass? Simply having a gentle word with the occupier. Make sure that they have got a copy of the bylaws and they understand the requirement to comply with them. Sometimes occupiers aren't given copies of bylaws when they take up residence within the scheme. They should be. Sometimes they're not, or sometimes they simply didn't read them. They haven't realised that they are breaching the bylaws. If you have that discussion and that doesn't seem to have worked, sometimes it's worth thinking about an alternate liaison person speaking with that occupant. Sometimes there's a personality clash when a chairman or other committee member may take up the discussion in a particular fashion, and sometimes you find that if someone else steps in and has a quiet word, that also addresses the behaviour. Now, I appreciate that your committee members are volunteers. You shouldn't have to do this. People should simply abide the bylaws, but if you at least give this a try and you can head some of these matters off at the pass, you're going to save a lot of time, frustration and money from not having to go through the bylaw contravention process. Because once parties start getting involved in the contravention process, sometimes they get a bit entrenched in their positions and they start just approaching it with a litigious mind rather than trying to address the behaviour. And as Mark mentioned in his presentation, it's incredibly important that you seek advice in relation to the validity of bylaws. I did an analysis, which I'll talk about in a minute, of all of the bylaw contravention cases that I could see at the time, and the large majority of contravention notices that were ruled invalid was because of the fact that the bylaw was invalid. So it's a huge problem. Make sure you get that advice early rather than getting partway through the process. So what's the correct process for issuing a contravention notice? You need to think of having the correct authority. You need to think of preparing it properly, delivering it properly. So in regards to authority, a committee must issue the notice unless it's a restricted issue, not the BCM or the resident manager caretaker. Whilst the committee, there is a practice of committees authorising body corporate managers to issue the notices. Providing it's properly authorised, I think that's arguable, but I recommend you don't adopt that practice. If I was on the other side, I would be arguing that's possibly an invalid delegation of authority by the committee, and I haven't seen that argued in a adjudication decision as yet, but it's certainly what I would argue if I was on the other side. So take the argument away, organise for the committee to sign it. The committee must formally resolve to issue the notice, and that's before the notice is issued. The committee has to hold a reasonable belief that contravention is going to continue or be repeated. And I'll discuss a case in relation to that in a minute, but the committee needs to think about, is that a one-off contravention of the bylaw? And if it is, then maybe you need to wait to see if it is repeated or likely to continue. And you need to make sure you take prompt action to try and issue a notice in relation to a current breach. We've been asked to prepare contravention notices for breaches that have been over 18 months old, and we have to give the advice at that point that it's just too late. If you want to issue a contravention notice, you need to do it promptly. In terms of preparation issues, you can either use the Form 10 or the Form 11 pro forma. They're not mandatory, but they're certainly recommended. We've seen many attempts by committees to persuade us that a letter they issued should be the same as the contravention notice, and I've never seen a successful one yet. You need to tick all the boxes in terms of complying with the relevant sections in the Act, and the easiest way to do that is to use the pro forma notices. The notice has to state the bylaw the body corporate believes is being contravened, so cut and paste the bylaw wording into the form or attach it as an annexure. Don't attach all the bylaws, because that just simply raises an argument as to which bylaw is specifically being contravened. So the better practice is just cut and paste the relevant bylaw wording. you need to provide sufficient details to identify the contravention, and you need to set those out with some precision. I mentioned that you can either enforce a bylaw contravention notice through an adjudication process or through the magistrate's court. You can only enforce it through the magistrate's court at first instance if there is sufficient detail in the notice, because the failure to comply with a sufficiently detailed notice constitutes an offence under the Act. And the section specifically says that if you don't have enough detail, there's no offence created. Now that means you can still process it through the adjudication, enforce it through the adjudication process, but it just removes one of your options. The notice also has to state the period within which the offender has to remedy the contravention. Now this can be a bit more difficult. You have body corporates required to act reasonably. You have to give a reasonable time frame. Now that's going to differ depending on the circumstances. Obviously, hanging towels over the balustrade breach, you can give a short time frame. However, if someone's changed the external appearance of their lot in contravention of a bylaw, then that's a completely different matter. It's always better to err on the side of caution, so give a little bit more time rather than having an argument down the track that you didn't give enough time. Because when these notices are challenged, they challenge everything. And again, as I mentioned, if insufficient detail the breach is provided, then no offence is created and you're precluded from enforcing through the magistrate's court. In terms of delivery, the notice has to be given to the person. It doesn't require personal service, as in the case of court proceedings, but it's important to make sure you can establish it was given to them, as the adjudicator of court can find that they're not satisfied it has been given to them, and that can then be an impediment in your enforcing the notice. It can be sent by post. However, the best practice is send it by registered post, so you get a signature, or hand it to the person personally, and that way there's no dispute about their receipt or the day on which they received it. If the notice is given in response to a request by an owner, when I mentioned that an owner can give a Form 1 request to the committee asking them to issue an enforcement notice, a contravention notice, then you have to give a copy of that contravention notice to the owner. If the notice is given to an occupant of the premises in relation to the occupant's conduct, you're also required to give a copy of that notice to the owner of the lot. So that's an important requirement as well. And finally, if a notice of future contravention notice is issued, it's valid for the earlier of either 3 months after it's given or a shorter period mentioned in the notice. So let's look at some case studies. So what's gone wrong? As I mentioned previously, the greatest proportion of invalid bylaw contravention notice is because the bylaw itself was invalid. In Maria Creek Estate, the committee relied on an invalid committee meeting in trying to issue the notice. When that notice was challenged in the adjudication process, the committee admitted that the committee meeting in fact had not been held, and in that case that invalidated the notice. In Marlin Cove, the committee issued a notice because it had been requested to by an owner, but again when the notice was challenged, the committee actually admitted they didn't believe the breach had occurred. They'd simply issued the notice because they thought they were obliged to when an owner had requested them to, but that's not the case. The committee have to, as I mentioned previously, have to be of the belief that the contravention is going to be repeated or continue. If the committee is not satisfied, then they should refrain from issuing the notice and the owner can take up the argument. Pintari is a bit of an interesting one. It relates to a hard floor bylaw. In this instance, it was thought the enforcement was premature, notwithstanding the fact that the hard floor was installed in 2003. A bylaw contravention notice was issued in 2013, which was then challenged. So there's a period of 10 years. There had been some correspondence between the parties, and the adjudicator said that the enforcement at that point was premature. Now, the reason is not the passage of time, it was the fact that there had not been a sufficient exchange of information about the hard floor acoustics between the parties, and so the adjudicator ordered that the lot owner provide that information to the committee. So sometimes it's not just a matter of going through the process. You do need to make sure that before you try to enforce the bylaw contravention notice, that the committee is acting reasonably. DeVille relates to a car parking bylaw where the committee issued a contravention notice on the basis that the occupier was parking two cars within the single car park space. Now, that bylaw contravention notice was challenged on the basis that the bylaw, in fact, didn't regulate the number of cars that could be parked in the spot. The occupier admitted that the real issue was, in fact, the fact that one of the cars was overhanging into common property, making it difficult for other cars to get around them. The committee in that case then argued that the occupier was clearly aware that they were not parking properly, that they were breaching a requirement of the bylaws, and that the technical breach by the committee referring to the wrong bylaw shouldn't be enough to excuse that conduct. Rather surprisingly, the adjudicator didn't accept the committee's view. The adjudicator said if the committee wants to allege wrongdoing by an occupier, it's incumbent on the committee to allege the correct breach and to identify the correct bylaw. So you're not going to get assistance often from an adjudicator in relation to these things. They're quasi sort of criminal in nature, so it's meaning that they're important documents, you need to get them right. So in terms of enforcing the contravention notice, as I mentioned, it can either be through the magistrate's court or through the adjudication process. So we'll look at the pros and cons of both of those. Now, the magistrate's court is a formal, more lengthy process. The adjudication process is less formal and substantially more speedy. In terms of legal costs, the magistrate's court is significantly more expensive than an adjudication application. The magistrate's court has that additional requirement to make sure that proper details of the breach are required in the notice, whereas it's not as strict in the adjudication applications. If you go through the magistrate's court process, as I mentioned, a fine can be issued for contravening the bylaw, and the maximum fine is 20 penalty units or $2,600 odd. Now, the adjudicator won't issue a fine, they'll order compliance with the bylaw. So you may then question, why would I go through the adjudication? Importantly, if someone breaches an adjudicator's order and you then proceed to enforce that adjudicator's order in the magistrate's court, the maximum fine becomes 400 penalty units or $52,000. So for all the cost of a body corporate seeking to enforce a contravention notice, I know what fine I'd prefer to have imposed on someone if we had to. And a lot of the time you find that occupiers do tend to comply with the adjudicator's orders, knowing that's the possible fine if they don't. So proceeding through the adjudication process is the preferred process. Now, the question I usually get asked is, if you go through the magistrate's court, will you get your costs back? Under Section 43 of the Acts Interpretation Act, the court has got a discretion to order up to 50% of the fine to be paid to the body corporate to recompense them for the process. So think back to the maximum fine. If you proceed directly through the magistrate's court, then you have a discretion to order up to $2,600 when it's going to cost you far, far more than that. Or if you go through the adjudication process first and then have to go to the magistrate's court, then you've got a much larger pie to get a slice of. So for that reason, we strongly recommend you do proceed through the adjudication process. I know it sounds a bit more convoluted, but I think there's a very good reason to do that. In terms of urgent bylaw enforcement, I must admit this doesn't come up very often. So putting it very briefly, a bylaw can be enforced urgently, so that's without issuing a contravention notice, where you're seeking an application for an interim order. So that means a temporary order until the final matter is determined, and if special circumstances exist. And so those special circumstances exist if the bylaw breach is likely to cause injury to people or serious damage to property or some other serious nuisance or special circumstance. If you get that interim order of the adjudicator, you then have to go back through the contravention notice process, issue the contravention notice and seek a final order. As I say, that doesn't come up very often. So try and summarise all of that information very briefly. If you're looking at the contravention regime, you need to consider particularly, and firstly perhaps, is the bylaw valid? You need to consider, is enforcement at that time reasonable? Does the committee have the appropriate authority to issue the notice? Is there proper detail in the notice in order for it to be enforceable? Is it being delivered properly? If you're proceeding to an adjudication, this is the point, if you haven't involved a lawyer previously, this is the point I think it's important to involve a lawyer, because it can be easy to lose if you don't know what you're doing, and it's incredibly important you get the order that you're seeking right, because you have to be able to enforce that order in the magistrates' court, and magistrates themselves are very busy and they don't appreciate a difficult order they have to enforce just because someone didn't give enough thought to what they were seeking. Take, for example, the situation of an occupier who has a party every Saturday night in a scheme. So you go get an adjudicator's order that they no longer hold parties on a Saturday night. Now you know what's going to happen, they'll move it to the Friday night. So you go and get an adjudicator's order that they don't hold parties. Now every time my wife and I go away for a trip somewhere, my kids are under strict instructions not to have a party. They don't. They can look me in the eye, they don't. They did have a gathering. And so it's important, they'll make great lawyers one day, but the important point is that you need to think about particularly what sort of conduct you're trying to curtail. It's the nuisance, it's the noise, it's the perhaps damaging or leaving rubbish on common property. That's the sort of behaviour you're trying to curb, as opposed to whether they're holding a party or having a gathering. Because the last thing you want to do is go through the process, realise you've got an unenforceable order and have to start the process again. And finally, when you're considering the preferred route for enforcing the notice, give some thought to, is the adjudication the preferred route, or is the magistrates' court? And in most cases it's going to be the adjudication process, I suggest. And that's it. Any questions?
Once you've got your order, how easy is the enforcement process in the magistrates' court? Do I need a lawyer? That's what I'm asking.
I would think you would, because it's in effect... Just repeat the question. Oh, sorry. The question was, if I have an adjudicator's order, then how difficult is that to actually enforce process-wise in the magistrates' court? It is difficult. The enforcement process is considered to be quasi-criminal, as I mentioned, meaning it has a fairly high level of responsibility to prove your case. It involves basically having a hearing. So if, for example, you say your order is that the occupier must not have noise past 10 o'clock at night or something like that, then you need to be able to provide evidence to the magistrate that the person has created an offence under the Act, and you need to be able to demonstrate evidence by witness statements, video recording, sound recording.
So you've actually got to go through the whole process.
There's actually a hearing, yeah, as opposed to simply putting in the application, sitting back and saying, well, let's see what happens.
Oh, so they're not going to trust the decision of the adjudicator?
Well, no, they trust the decision of the adjudicator, that there's an order, they must not breach the bylaw. You have to then prove that they've breached the bylaw. They breached the order. So this is breaching the bylaw after the order's made. You need to establish that there's actually a breach after the order's made.
If there's a positive adjudication order, as in they have to remove a certain
alteration without their consent.
Alteration or whatever. And the order basically says you are required to remove it. If they don't remove it, surely all I need is a photograph.
Yeah, so the question is if it's, for example, a bylaw where they're not entitled to, or they have to remove an alteration which they did without consent, then that would be a far easier thing to do. And there is a process under the magistrates' court where you can request, for example, a summary judgment application, or you could request even a decision on the papers in some instances. So that's, again, depends on the order you're trying to enforce. And in that instance, it's going to be somewhat easier. But you still need to make sure you're complying with the right court forms.
Okay. An urgent order, would you be able to, if someone went overseas and they parked their car in a position that blocked another car?
That's an interesting question. So if they... Hello? Sorry, the microphone cut out. If the person had, say, blocked in a car park, that's an interesting question as to whether that is special circumstances. The answer is I don't know the answer to that. If someone was locked in the garage in their car, I think that would be a situation where the body corporate could tow the car. If simply someone can't get their car out, the answer is I don't know. I'd have to look at the authorities myself on that point. That might affect the body corporate's position as to whether the individual lot owner who's being parked in have got their own rights. Of course, they may have a nuisance claim where they're entitled to take action to abate their nuisance, and so that's something which the owned lot owner may be encouraged to seek their own legal advice, because sometimes the restrictions on the lot owner is not as bad as the restrictions on the body corporate.
Andrew, I come back to the slide that was the correct process. And I know you give the bylaw breach notice to the occupier, in the case of a tenant, with a copy to the lot owner. What is the role of the letting agent?
So the question is... The question... sorry, not working. Can you hear me now? No? Seems you're back on again now. The question is, you're required to give the notice to the occupant in relation to their conduct, and you have... No, doesn't like the question, sorry. So you have to give a copy of the contravention notice to the owner as well, but what about the role of the letting agent? The letting agent is a private contractual relationship between the owner and the letting agent. Now, the contravention notice is being given to the owner just so that they're aware of it being issued. It doesn't require the owner to comply with the contravention notice because, again, we're addressing the conduct. The conduct is that of the occupant. So the only person that can be enforced against is the occupant, unless the owner is the recipient of the notice, for example, altering the appearance of a lot or something. So the fact that you're giving the notice to the owner doesn't mean you can enforce it against the owner. It's just a requirement that you give a copy to the owner if you're giving it to the occupant.
So do you have to go through the letting agent to give that, or can you give it directly to the occupant?
You're required to give it directly to the occupant. So I would think that you run a bit of a risk if you give it to the letting agent, even if they say, give it to me. I think that you could give them a copy if you want to, but I think that you need, because you could probably serve the owner's copy on the letting agent, but I think that you're better off if you have the owner's direct address to giving it directly to the owner, because that's what's required by the Act. But I wouldn't be serving the notice on the occupant by giving it to the letting agent.
And in regards to a resident building manager, how can they actually speak to that tenant, or do they have to go to the letting agent to actually speak if you're going to just like speak?
This comes back to the slide I mentioned about trying to head things off at the pass and having a quiet word. Caretakers are not able to or obliged to enforce bylaw contravention notices. They're often required to report them to the committee, and they can also be required under the agreement to have a discussion with the occupant first before contravention's reported. So it really depends on the terms of the caretaking agreement as to whether they're obliged to. I certainly don't have any problem with the caretaker having a discussion with the occupant, and certainly if they're in their letting pool, it would be wise for the caretaker to do that, but just realise that the caretaker may not be obliged to do that depending on what the caretaking agreement says.
And there's also the RTA rules as well.
Well, yeah, but again, the RTA, so the question is, how do the RTA rules impact? Well, that's a regulation between the relationship of the occupant and the lot owner, and it's not really a matter that the body corporate can rely on. So the lot owner may have rights and the tenant may have rights under the RTA regime, but that doesn't often assist the body corporate.
What I was meaning is under the RTA thinks it's the letting agent that has to speak to the occupant. So in that respect, my understanding is that the
Yeah, well, in relation, so the question is, if under the RTA regime, is the letting agent required to liaise with the occupant? I think in relation to any formal process, that's the case. But again, I can't see any harm. It's an informal process. It's simply a, hey, did you know, can you please stop complying? In terms of any formal process, you need to make sure that you're giving it directly to the occupant and that you're giving it directly to the owner.
Are there any other questions?
Just one.
Yes.
Passing a bylaw and applying it retrospectively, my understanding is you can't do that.
That's correct. So can you retrospectively pass and enforce a bylaw? No, that you can't. It regulates future behaviour.
In the fact that somebody might do something that noise, for example, flooring, then it becomes an issue, then the body corporate can only deal with any new cases that come forward from that point.
Yeah. However, so it does depend on the bylaw and the breach. So, for example, a hard flooring bylaw could only be enforced from after the CMS is registered,
Yes.
as opposed to the passing of the bylaw. In relation to a repeated breach, such as a nuisance bylaw or car parking bylaw or something like that, well then, if that person has previously parked, that doesn't justify them parking in or breaching in the future.
Thank you.
Any other questions? Thank you very much, Andrew.
Thank you.